Good morning, everyone. I hope everyone is well today and are enjoying the good weather. First, the answer to last week's question. The fact that the person who had an order of protection against them was misled and came to the house based upon the invitation of the person who the order of protection was in favor would create a presumption, a rebuttable presumption, I should say, that in fact they did not violate since they were invited under false pretenses, and therefore that allegation would not be legally sufficient in a court, although it might not be done so immediately. It's always possible the police would have made the arrest, but they would have gotten freed eventually and not gone forward with the violation of the order of protection at some point of time in a court of law. Today's question is one about child support. What happened is a client of mine earned $100,000 and paid child support based on that $100,000 income. A number of years later, he married someone who was a $450,000 earner. So together they had an extraordinarily nice income. They went out and they wound up buying a house with like a $6,000 mortgage on it. Well, unfortunately, the high earning spouse passed away young, and now my client could not afford the house anymore and couldn't afford to pay child support. But he really loved the house, so he went into court to see if he could get a downward modification because of the change of circumstances that he could not afford to live and pay for his mortgage. Now, do you think that that's a legally sufficient change of circumstances to get a downward modification? That your expenses increased and the income decreased through no fault of your own when in fact this other spouse passed away? You decide. Legally sufficient, yes or no. Thank you and have a great day and stay safe.